Hi, everyone. This is Dallas, one of the producers of Ideas of India. This podcast is dedicated to progress in all things, so in the show notes, we've linked to a short survey on how we can improve and would really appreciate your feedback. Thanks in advance, and thank you for listening.
Welcome to Ideas of India, a podcast where we examine academic ideas that can propel India forward. My name is Shruti Rajagopalan, and today my guests are economic historians Tirthankar Roy and Anand V. Swamy, speaking about their latest book, Law and the Economy in a Young Democracy, India 1947 and Beyond. Tirthankar Roy is a professor in economic history at the London School of Economics. And Anand V. Swamy is the Wilmot family 3rd century professor of economics at Williams College. We spoke about the long shadow cast by colonial laws and institutions in India, the mindset of paternalism and how it hampers freedom of contract, the fear of markets and its impact on economic policy, land reforms and eminent domain, labor law, and much more. For a full transcript of this conversation, including helpful links of all the references mentioned, click the link in the show notes or visit discoursemagazine.com. Hi Anand, hi Tirthankar, welcome to the show.
Hi, Shruti, it's lovely to be here.
Same here.
One of the things I've learned from both of your work is that history casts a really long shadow. But in this book, I feel like the additional element is it's not just what the old institutions are leaving behind. It is that they are getting entangled with the new political economy in such a way that there are a lot of frictions and it's not very smooth transition, right? So there are some incompatible institutions that are left over. There are some, just sort of zombie legislation which is left over, which no one really follows. There's a lot of new norm setting, which is trying to replace these old institutions. And it just simply doesn't work the way it's meant to work. Is that a good way to think about the two volumes?
No, I think that's an excellent, very handy way of describing what we wanted to do here. I think in the long run, law and politics overlap a lot, and that's one of the messages that are coming through in both projects. But it doesn't necessarily overlap in the same way in different fields of law. And there are other influences as well. For example, the expectation or the desire to connect India with the world economy, the globalization impulse, which was quite strong in the colonial times because Britain was a free trader, of course, but even other than that, it was a major capital exporter. British Empire was founded on this idea of economic exchange and transactions. Something quite similar has come back in the last 25, 30 years. And in both times, the desire to achieve some degree of parity between global law and Indian law was also an impulse. So politics matters, globalization matters. And I think these are the lens through which we wanted to describe the evolution of economic laws, property, corporate and commercial contracts over the long run. And the 1947 comes as a break, of course. It's a very significant break, but you can also see some continuity in the project before and after.
Because we worked on both these books for so long, each of us, I think it's sort of, you look at books themselves through a different lens at different times. So this morning when I was thinking about it, I was thinking about really, maybe there are two big questions that we followed through the two books. One is sort of where did it come from, the origins question, and then the question that, anybody who's lived in India or worked in India, why is it so cumbersome? And I remember a long time ago being struck that, we were reading this literature about how having this common law inheritance was a wonderful thing. And it just jarred with the sense that I had growing up in India that law is something terrifying. And, the last place you want to be is in court. And so at some level, I was already asking those two questions, which is, like I said, where did it come from and why is. And so the answers to those questions then are sort of traced through both books, I think.
We talk about a lot of this, ease of doing business and where is India on the rankings. It's about moving up a couple of steps or moving down a couple of steps. Now, what you point out is that a lot of the current lack of ease of doing business, if I can use that phrasing, it comes initially from a colonial culture which is extractive, right? So a lot of the laws at that time are from the point of view of an extractive state, right? So whether they're extracting revenue, which is the initial point of contention, or later they're extracting natural resources, then they're extracting for the war effort, that of course keeps changing. But the fact that the colonial government is developing a particular kind of institution and state capacity for an extractive state very much remains, right? Then you bring us on to the next stage, which is this sort of dirigist development mindset, right? So that is the next 30, 40 years. And once again, there's some continuity from war controls and things like that. But now you get a different kind of state, which is not intending to be an extractive state, but a development state, but still very high level of state control, relatively low state capacity. How would you describe the modern Indian state, sort of post-liberalization Indian state? It was supposed to move from a control economy to a regulatory economy. I know how successful we've been, but if you were writing this book 3 decades from now, what would your perception be of what's happening now?
Yeah, I think a short version of it might be that, just going back to your earlier point about continuity and change, in some sense, the problem of land and credit, in some ways, there's a lot of continuity. I mean, I grew up learning Indian economic history and thinking about, the British Raj being largely laissez-faire. And I think it's, true if you think about the firm and and trade and so on. But actually, intervention in the land market goes back to the late 19th century. And there's a set of intuitions that come in there, in particular the idea that land transactions are risky for poor people and harmful to poor people. And that actually stays through the colonial period. If anything, it intensifies, and it's still very much part of the way we approach the economy, I think. So in that dimension, you have continuity. When it comes to corporation and trade and so on, then I think there really is a difference where the statist approach after independence is really quite sharply different from what preceded it. And after 1991, it seems like we're struggling with both those inheritances, that you're pulling back from SICA and MRTP and all the rest of it, but that process is a little bit slow. But it might even be slower when it comes to the land dimension, where change is harder and resisted more, and probably because it's more associated with the daily lives of lots of people.
Yeah, let me extend this idea of colonial inheritance or legacy. You are absolutely right that the revenue or the fiscal drive or the attempt to raise more revenue, that was quite paramount in deciding state policy, including legislation. But there was something else, and we now understand how the colonial states worked worldwide much better than before. And one of the things that many colonial states were trying to do was also to create a broad legitimacy and finding out the sections of population where that legitimacy could stand. And the impulse in British India was because the peasants paid a lot of the taxes to give something back to the peasants. And also from the East India Company's rule in the 18th century, there was a general idea that if we rule India by some basic Indian precepts, then we are better off. People will accept that rule. Now, the way that was implemented was to incorporate a lot of religious injunctions and ideas into lawmaking, into legislation. And you see the legacy of that in women's property rights, for example, or adoption rights, or inheritance, succession, testamentary rights, which were quite peculiar in India, sometimes weaker historically. Now, that has been a legacy passed on from colonial times to the independent times, but independent states has been struggling to deal with it. It's very hard to say that religious references will be completely invalid from now on. You cannot do that. And you cannot do that also because the Constitution guarantees some space to personal law. So it's been a struggle. It's a legacy which is probably needed a reform a long time ago. But that reform has been very slow and very piecemeal in coming.
Also, Shruti, I just wanted to add to that about the issue about the extractive state in relation to land. And it's it's an uneven story, right? So I think if you start with the permanent settlement in 1793 or you look at the early Rayatwari, it's certainly true that the tax rate is really high. And so that's, sensible to talk about an extractive state. But I think after the mutiny and, into the early 20th century, the proportion of agricultural output that's being taken as tax in the zamindari areas is really very low. And by the end of the colonial period, it's really quite small. So I think post-mutiny, I think David Washbrook made this point so well. It's not necessarily that much about extraction as it is about simply preserving British rule and not rocking the boat. Just if you look at that single number, which is what proportion of output was the state taking as tax, I think it's very different between 1795 and 1940.
I think that's a point well taken. But the nature of the extraction also changes, right? So I think of, for instance, something like the Forest Act, which kind of nationalizes forests and any land which is not falling under your very classic, Anglo-Saxon sort of property rights regime, just nationalizes or de-recognizes it overnight. And that is a particular kind of extraction, right? It's not exactly the same as revenue extraction, which you're absolutely right, keeps coming down in part because the Permanent Settlement Act is sort of fixed a rate, right? And then, between inflation and everything else, it keeps getting chipped away. But, the kinds of resources, the way timber was used for railways, the way railways were used for directing, raw material and actually, finished material for the war effort, both the wars. I still think there is that tinge of an extractive economy. I don't know what percentage of the GDP that might end up at, in a way that it's very easy to calculate revenue as a percentage of GDP, right? But in my mind, that never quite goes away. Though you're right, the post moving from the company to the crown, there are some tendencies to think a little bit more about the people of India and preserve the rule and not have riots and rebellion.
I mean, you are absolutely right in raising this huge open question about legislating the commons. And it's a major subject in understanding the evolution of law in the developing world, especially the tropical world, partly because a much larger proportion of the population depend on the commons in these parts than in the western or temperate zone world. Whether it's the savanna land for pasture or forests or water works, water is much scarcer here in India. So in a variety of ways, that's a huge field where you needed regulatory law, either to conserve, regulate the use, or permit some kind of sustainable use. Much of that legislation has been a work in progress. Most colonial powers didn't have a very clear understanding of how important the commons were for livelihoods. And it's a worldwide colonial topic that they under-legislated the commons, sometimes took it over, nationalized it, as you said, thinking that this is an economic resource which can be exploited and it will give us more taxable money. And then realizing very quickly that if they really do this, then the commons will disappear very quickly. So there were both these impulses, conservation and economic exploitation, working behind regulation of the commons. But fundamentally, the kind of laws that economists or activists would want, which will make for a sustainable long-term use, were a process. It started in a very small way, very patchy way in the colonial times, and we are still working on it. I mean, water law, for example, is a completely open field.
Yeah. And as is forest law, right? In fact, even the legislation is quite sparse. Most of it is through judicial pronouncements and, future orders, like, a lot of these continuing mandamus orders that keep coming from the courts. And that's really how we have shaped how we think about, commons versus either community owned or even individually owned forest rights.
Can I just make one intervention on that point? In relation to sort of common property and forests and so on, you're absolutely right. So there's the extraction aspect of it. But there's the other piece of it, and that obviously had to do with the fact that the British were ruling India for British interests ultimately, right? So there was no getting away from that, whatever you were looking at. But it's quite striking that when India does become independent, the forest law as it exists then is basically considered adequate, right? So there's the National Forest Policy of 1952, which basically says that, look, the fact that you're living in this village and there's a common property area there and it's of use to the nation, don't think, you're special because you live next to it. So there's the relationship between the state and the local community. That's where a lot of the negotiation and change is happening. So, I'm thinking if it's 1965 and I'm losing access to the forest, it doesn't matter very much to me which state is taking it away, right?
Absolutely.
And it's only now that with the Forest Rights Act and so on that you're really getting some muscle into this idea that local communities should have rights over local resources.
I think that's a lovely point, that it hardly matters whether the resources are being directed towards a central plan by the Indian Planning Commission or whether the resources are being directed towards the British war effort or something else, right? The fact of the matter is that the local community doesn't quite have access to it. But in the process, what has happened, as you point out beautifully in the book, both in your land chapter and in the chapters on the environment, that this has affected both those areas, right? We don't have a sensible way of governing the commons. So that's, problem one. If you're thinking about it from the point of view of economic efficiency, a lot of the new court rulings have come up in such a way that they're almost like anti-commons, right? There are too many veto points. So you can't get much done and there isn't a single holdout. It's become like a gridlock economy. On the other hand, if you don't have sufficient veto points, right? If the state is the only authority or ministry is the only point of clearance, then you get a lot of this mining activity a little too quickly. In fact, in a lot of cases, you have the leader of a particular tribe or the pradhan of a particular village who's basically the person whose name is on the ledger and has signed off the entire community's rights to a particular firm, or in some cases, even Government of India firm, right? So the whole thing is a little bit bizarre. So I understand that there's no way of doing this from scratch today. But if there were an attempt to rewrite this, what is a sensible way to think about land law, forest law, and environmental law, sort of the intersection of the three? And what are the first principles one must keep in mind before putting this in place?
It's a big question, Shruti. I just made one observation that comes off the top of my head, which is that if you go to this issue of land acquisition and eminent domain, the weird thing about the notorious 1894 Act was if a land is put to a better use, then it's going to produce more. To an economist, sort of the most natural way to think about facilitating that transfer is to share the benefits of the new increased productivity with the original owner. But the 1894 law actually forbade that. Right? It didn't just not just have that. It actually said it could not be. You could not take into this value. And so I think some of what's interesting right now, to me at least, of getting past this quagmire, is ways of going past that and sharing the profits.
The surplus. Yeah.
So I think in the 2013 law on land acquisition, there is this provision that if a new owner resells...
40%.
Yeah, 40% has to go. And then, with the minerals, there's now legislation that about sharing royalties, with local communities and so on. So that's at least one way past, I think, this tangle, that is.
I'll echo Anand that this is a really big question, and I don't think we can have a very quick answer to it. But also, I think the answer will depend on what kind of resource we are looking at and how acute the drive is to make that resource more exploitable commercially. My sense is that with land or forest land, the agricultural use or industrial use, that impulse is a little weaker now than, say, 40 years before. Precisely because the economic structure has changed, the livelihood composition has changed, and a lot of people would, if not give up on industry, they're not so fixated on industrialization as the road ahead. But there is going to be a fierce and more intense battle ahead on water. And that's one of the trickiest thing to legislate, because water is like a mine. You have rights on surface, but sometimes the water comes from underground, and these two types of rights. You own a well, which is a private property, but the well is drawing water from a common property, and no one knows the exact qualities of that water body. That's a global problem. It's not just a colonial inheritance problem. It's a fundamental environmental problem that we do not have the perfect solution for. The other thing that I wanted to comment on your question, the other comment I had was that this process of moving ahead on legislating the commons in a sustainable way has to be, and it is becoming more provincial. It's not a federal thing anymore. You can see that also in the level of activism among local communities in protecting their livelihoods or their dignity or their dependence on the commons. The fact being that in Kerala, these popular protest movements are much more frequent, much more successful, more intense, more long-lasting, to the extent that some people would think that these communities have extracted a significant political autonomy where some of these movements appeared. Something that you cannot say for, say, Narmada Bachao or Chipko. It is a very regional cultural thing as well. India's own ecology is very diverse. So you are going to get quite different types of movements and different types of solutions in regionally.
I think there's two types of distrust at work, in terms of arriving at solutions. So, I mean, as economists, trained and thinking about markets and so on, we tend to think of, state versus market. And I think part of the problem is that, well, I wouldn't necessarily call it a problem, but part of the issue is that actually there's distrust of both.
Yes.
So when it comes to eminent domain, for instance, I think we argue in the book that one of the reasons why the 2013 law was written in that kind of blunt way, where you say, okay, 4 times the price has to be paid for, was in fact, we quote one of the people who was behind the legislation essentially saying, I wanted to take discretion out of the hands of the government. Right. So at that level, there's a and of course, we all know for all those evictions and so on, that if you're going to lose your land, you had good reason to worry that you wouldn't get compensated. That, I think, has to do with the credibility of the state. That I can actually see, concrete ways of addressing via, like I said, profit sharing and so on. But there's a deeper sense, like I said, which goes back a very long way, which is really about intuition, which is that, putting poor people into market transactions in this legal system is intrinsically dangerous, right? So, as you know, many of the land reform acts actually forbade land lease, and there are so many other restrictions. There's been a model tenancy act now out for God knows how long. But people are not biting on it, right? Because I think that intuition is very deep. And it may have something to do, I think, with the fact that in a country that's been as poor as ours, insurance is a very big deal, right? So as economists, we tend to think about growth and what will actually, expand the economy, expand the pie, and so on. But I think a lot of what people are worrying about is how do we stay out of starvation or how do we stay out of destitution? So that combination of thought, that I think is a trickier thing to legislate away, or negotiate away.
I think one of the most fascinating things is this problem India has with freedom of contract, right? Of course, it's worst in land matters, as you've pointed out over and over again, but it's also pretty bad in labor. Is this coming from sort of like an imperial culture? Oh, these, poor indigenous people, they don't understand law and they can't be trusted to trade with one another, even though it's one of the oldest trading civilizations. Then comes the socialist regime, which is, they got conned by the East India Company and then by the British Raj. These poor people don't know how to trade with each other. So now it's a paternalist sort of, socialism, but really paternalism coming in. And now post-liberalization, they're like, oh, there's all this crony capitalism and, all these big mining firms are going to take Adivasi. They really can't be trusted. And it's, of course, worst with farmers, poor people, Adivasis, women. It's so difficult for me to wrap my head around this because Adam Smith tells us human beings have the proclivity to truck, barter and trade. And everything we've seen in 250 years of law is to not trust people to truck, barter and trade. So first question is, where is this coming from? And why is this intuition so deep in India?
It's a wonderful question. First of all, one of the harshest labor law was a colonial product, one of the early labor contracts, which made escaping a contract a criminal act. And that came into being in the 1850s and in the plantations, and it remained in force for quite a long time. Anand has written about this. So, yes, but then if you look at the origin of this law, it's not exactly colonialism. It's coming from a British tradition where, again, labor contracts were covered by criminal law or penal law for a long time. So breaking a contract is a sin, not just a civil offense. That sentiment was carried over into many parts of the British Empire. And the employers of, say, plantation tea estate workers liked it because they thought that these people, unless they are forced to stay on, they will escape, back into their villages and never turn up again. That's bad for business. So they quite liked this kind of law. In the 1910s, 20s, by that time, the factory workforce was quite large, and many of these employers were not British anymore. They were Indian employers. At that time, there was a different kind of drive working towards labor legislation, and that came from the nationalistic politics. Both capital and labor were organized under different trade unions, which were led by political parties. And the legacy of that is something that post-1947 India has been living with, which is that the organized workforce is very politically organized and politically connected. The parties or the political campaigners speak for them, which is something that connects to what Anand was talking about, which is that the poor people, if they're left to the market forces, are likely to get shortchanged or exploited. And that sentiment works in labor law. And we all know that a lot of new new clauses were added to that to protect that interest. The problem we now see, however, is that the other side of that kind of protection, if a worker or an artisan or, say, a street vendor is always represented by somebody, then an honest deal doesn't go through. I mean, the risk that I may be fully aware, I'm politically weak, but I may be fully aware of what I'm doing. I have full information, but I don't have the capacity to carry out a sale because either a law or a powerful counselor or somebody else can come in the way. That's a different kind of risk. It's also, again, an exploitative situation. And a lot of that we see in everyday life all around us.
I think that's a great point. The middleman problem, right? And this is also, again, like, many 100 years worth of legacy. At different points, it's a different middleman. So you're right that there has never been anything resembling that sort of laissez-faire freedom of contract where there's genuine meeting of minds and genuine consent that is given. And then everyone is now suddenly very, very worried about, if there isn't genuine consent, can we have any kind of contract at all? And all sorts of impositions on it.
Shruti, on the connection with this, one thing that it just reminded me was that, as you've been writing these two books, you're always looking for the big picture, right? So you're diving into the detail and you're trying to find the big picture. And one of the things that's always struck me is that the story does vary depending on which part of the economy you're talking about. So in the labor market, on the one hand, we are used to focusing on the industrial worker and the protections and all these complaints about excessive protections and so on. But in fact, huge swaths of the Indian workers are essentially unprotected, have been essentially unprotected for a very long period of time, right? Now there's some change. I think T.S. Popula has a nice paper where he makes the point that really, all this discussion on a tiny fraction of the labor force and the rest of the situation is really quite different. The other end of it really is, there's again, Narega and the right to work. It's interesting that in a world where sort of the minimum wage law is like largely ornamental.
It's an insurance scheme or a safety net, right?
Yeah.
It's the downside risk that you were talking about. This is one way of protecting the downside risk.
Right. And the other thing I just wanted to mention in relation to sort of this persistence of the skepticism of the market. The labor laws have been changed, as you know, right? In the last, was it a year ago? Less than a year ago. This big reform. And there's so much talk about did it get resistance and it didn't and it went through and so on. But if you look at the clause that has attracted the most academic attention, at least, which is letting a worker go after you're at a size 100, that's the one people want to change. It has changed, but it's only changed to 300.
300, exactly.
Right.
We still don't like scale in India. We have a problem with scale.
What's true, I think, is that the law, I think, allows a state to make a different choice. Each state can. But it still is interesting that in an era when there's so much talk of the market, what you've really done is go back from Indira Gandhi 1982 to Indira Gandhi 1976.
Yeah, that's a great way of putting it. I always thought that for scale, the binding constraint was labor. Right? So we have this nonsense law, which, is it 100 people? Is it 300 people? This is fundamentally the reason India never became a manufacturing hub like, Taiwan or even like Bangladesh right now, right? And I thought that was the relevant, constraint that we need to relax. Now I'm not so sure anymore after reading your book. Because is the relevant constraint for scale MRTP and SICA type laws? Is it difficulty in assembling large parcels of land? Is it labor? Is it environmental clearance? Or is it something completely different that, even if we manage to relax all of this, because we have this terrible tax regime, there are going to be a lot of firms that prefer to be in the shadows in the informal economy because, if they genuinely paid that kind of tax, there's no way they could be competitive in the market. So what is a good way to think about or investigate what is the relevant constraint in this kind of thicket of regulation?
I don't think that there is a kind of magic bullet or magic solution to generating more investments. But the theme that is common to all the examples that you cited is that the more regulation you have, the more procedures you have to follow and the more boxes you have to tick for a private investor. And the more you do that, the more exposed you are to political interference. If not outright rent seeking, implicit pressure to create jobs or create jobs for our people, that sort of thing. That goes on all the time in a sizable investment almost anywhere. But part of that, I think, is a procedural problem. If you can make this process more transparent and more mediated by electronics rather than human beings, probably things will get a bit better. At least investors will understand the system much better than otherwise.
So, Shruti, I think the problem you're raising is a tricky one, really. And I think if you put it in sort of economist jargon, you're essentially saying that in an optimization exercise, if you've got multiple potential constraints, how do you figure out which is the one that is binding, right? So I think economists and econometricians have really had a go at it. There's very different results. My sense actually is that the labor law probably matters, but first of all, it's not necessarily the one that everybody focuses on, which is this 100 and 300, but it's what I think Manish Sabharwal or someone called regulatory cholesterol. It's like 100 different things. But it's also the case that, with the fixed term employment being allowed and contract casual workers, maybe this is not the one that's really biting. If your listeners who are sort of technically oriented, there's a very nice paper by Achyut Advaryu and some others in Review of Economic Statistics, where they actually look at whether, when you get a demand shock, how much are you able to adjust your number of workers? And they look at places where labor laws favors the employer versus the worker. And they find, in fact, some differences in employment. But it's interesting, they don't find any difference in profits. They don't find any differences in output. And eventually the paper speculates that people are working around labor law by using contract labor. And then there's a later paper in the JDE, the Journal of Development Economics, which sort of seems to support that. So I think there's a very clear theoretical case for it, for labor law of this particular type around retrenchment being a constraint. My sense is that this is not such a big deal. In the book, we mentioned that there was some relaxation of this retrenchment rule in Rajasthan some years ago, and you're not seeing any sort of big bang for your buck.
This anxiety about labor law is a kind of legacy of a time when economists across the board thought that industrialization is the way to go. And many of these laws were tuned to the manufacturing workforce, the manufacturing work site, the kind of work that happened in a large factory, things like metals, machines, chemical factories, which were the priority in the 1960s and the 70s. And the labor laws attempted to protect people working in there. And that's the kind of legacy we are living with. But that doesn't mean that if you reform labor laws, there'll be more of that kind of factories. I mean, India is not moving in that direction at all. It's moved away from that direction. And the huge service sector employment is a completely different game altogether. This anxiety about 100 and 300 and the kind of magic bullet is an archaic kind of discussion. I mean, we need to think of labor law in a completely different way.
I think the additional problem, which also you point out in a book in many different ways, is, if you're moving away from a labor inspection control kind of an economy, right, which used to be there'd be a labor inspector who would show up to the factory site and check if the capital labor relationship is smooth and functional. If you're moving away from that, now the 100 and 300, it's a matter of detail, but we need to move towards some kind of contract enforcement, right? And the biggest problem in sensible labor relations between the employer and the employee is that the courts take just too long. There is no way to enforce a contract. So all your contracts are taking place in sort of like the shadow of the law, right? And the moment you go from within the law to the shadow of the law, you're now relying on networks and caste and power structure and middlemen. And so now you've just gone from what, Doug North and Weingast and all would call like an open access order to a limited access order, right? We've kind of pushed people into that because the contract enforcement is completely broken. So there seems to be an even bigger failure, which is not just the detail of the 100 versus 300 and, the rest of the labor regulation. But even if we got the most perfect labor regulation that, economists who work on the market can agree on, who's going to enforce this stuff?
The enforcement problem, again, it just seems like something that started in the colonial period and just steadily got worse. At some level, it's baffling. I think we begin the second book by pointing out, I think we have some figures on how many judges we have per million people.
Yeah, the number is supposed to be 50 per million, and I believe you show that it's 1 per million. Right. And that's the allocated number. We have about half of them are vacant. So I think the number might be even lower than you think they are.
Right. It's hard to make sense of. The best guess I think we have in the book really is that, at least for the current day, there's no electoral payoff. There's no big investment in changing the law. Is not going to yield return in 2 years or 3 years. You can't put it on an election poster. You really need a long-term horizon for that. I suppose the other piece of it, I think Tirthankar knows this and has written about this much better, that the parts of the economy where people had really needed this, that is quick contract enforcement, it seems so difficult to work with to reform the existing system, to do this sort of what in the US you would call an end run around it and set up these tribunals, right? So you've got this now not a sort of a different kind of legal dualism is I think what people call it.
No, absolutely.
This is a great question about enforcement. I mean, part of it is a very macro and very long historical thing, as Anand mentioned, the judicial infrastructure falling constantly behind population growth or economic change. I mean, it's not a post-1947. It's not something that happened in the last 20 years. It happened over the last 150 years. But it's the same problem. There is underinvestment in the infrastructure. So it's not just labor law, but all forms of disputes. If it is a civil dispute, it will take an enormous amount of time, to the extent that I hear from gossips that makes more sense if you have a dispute to file a criminal case.
Absolutely.
So that's just harassment, of course. But a lot of people are taking that road because civil cases are so hard to settle easily. But part of the problem is also that, I mean, this is quite evident in, say, the big issues in corporate law reform, like insolvency, bankruptcy. Part of the problem also is that there is a regulatory overlap, and that the Companies Act gives you a way to file for insolvency, but then other types of laws or regulations will prevent you from doing that or make it subject to some kind of licensing procedure. A judge often has her hands tied about how to settle certain cases, and you would have examples of that almost everywhere in tenancy contract, labor contracts, everywhere, that you can settle a case by referring to different types of law.
And this is also why our legislation is getting messier and messier, right? This is why you get 4 times the market price and 40% of the profits and those sorts of things that are now entering legislation, because you've messed up contract law to such an extent and its enforcement is, so sort of unreliable that the only way to protect large groups of people who especially have some kind of political traction is now to write this stuff into legislation, making legislation itself more complex and messy. I want to come to land law. I mean, I want to start right at the beginning, and I've learned some of this from your past work, Tirthankar. This is, the economic history of India, where you take us back to 1790 and the Permanent Settlement Act. And the Permanent Settlement Act, as you point out, it's this way, for the East India Company to quickly generate and manage land revenue at scale when they have maybe 200, 300, company officers who obviously can't go around collecting revenue in the entire Diwani of Bengal, which they had won at the time. But one of the consequences of the Permanent Settlement Act is that it sort of brings in or creates new rights and property. And this is one area which has never been clear to me. And was the right that was created in favor of zamindars a right to ownership of property, or was the right that was created the right to collect revenue? Because I know that the right to collect revenue itself was an alienable right, that when they failed to, collect and pay sufficient revenue per the Permanent Settlement Act, their right could be auctioned away. And it did happen with many people. And at some point in 1947, we seem to have conflated the two, right? Zamindars become the de facto owners of land, as opposed to actually just being revenue collectors of land. And that, of course, leads us to all the eminent domain problems that you cover in the second book, which is, post-1950 with the new constitution. Now we need to do land reform because the zamindars have high concentration. So can you take us back to the origin point and sort of help untangle this mess?
It's exactly as you described. When we talk about property rights, historically, there are different types of rights embedded in that word, that phrase. Right to use an asset for income, right to collect taxes on somebody's behalf, or the right to own, which means I am able to mortgage that asset, or I'm able to sell it, or I'm able to pass it on to the next generation, or anybody I please. Now, the general point of emphasis of all colonial land reforms in the 18th century, later in Asia, in Africa, in Southeast Asia, was to recognize just one of these rights, and that's ownership. Exactly as you said, and de-recognize all other forms of right. Now, of course, they were doing it with the understanding that the person who gets this very strong, unencumbered ownership right will then be incentivized to pay more taxes or pay taxes regularly. So there was a revenue angle, but the general understanding was that if you make land free of all other types of rights and make it a pure ownership asset, it will be used more productively, or it will be sold to the potentially most productive user. So there was a sort of utilitarian market-oriented logic behind it, but there was also a kind of political calculation that the people who are getting it are in 1790s Bengal. The people who are getting this right, the zamindars are the big shots in the countryside, and if you give them this unencumbered right, they will probably feel happier and they'll need to employ fewer soldiers to be able to collect taxes, and that will be politically wise as well. In this way, the politics entered this calculation, but fundamentally, the direction of the reform was just this: ownership and nothing else. And you see it worldwide in the colonial land reforms. The problem, of course, is that when you create strong ownership right, then the commons become a big open question, because you cannot have ownership of the commons, certainly not private ownership. So the only kind of right that works there is right to use. The more you are obsessed with ownership, the less you are able to deal with the commons problem.
On the common segment, just wanted to jump in there. The text itself actually built in long-term trouble, because essentially what it says explicitly is we recognize this person's right to do this, which is collect taxes and keep a share and so on. But then it also does, I think, some very explicit language. It says this is not to deny other rights that exist of the type that Tirthankar referred to. And I think Peter Robb has a very nice analysis of this. This is really a weak state which can't do much. So it does what it can, and everything else, and again, what in American parlance you would say, it punts. It's like, we'll deal with it later. And so then the other rights get fought over, 200 years? I mean, the Bengal Tenancy Act, 1859 and 1885, and then all the way to Operation Barga. I mean, all those rights beneath the Zamindar are being fought for the next 200 years.
Yeah, and what I find fascinating is I've been tracking eminent domain cases. I went back to 1790 because of both of you. The other thing I recently learned while tracking cases from that time, when we think about eminent domain, what is the compensable harm when property is taken starts becoming quite clear, right? And normally, you would think that, if the presidency of Bengal wants to put in some kind of bridge or canal or some irrigation work, then it's going to compensate the zamindar, and, he'll hopefully pass it on to the par zamindar or, one of the tenants, because that area got flooded or a bridge went over their piece of land or something like that. But when you actually read the cases, what they start pointing out is the harm that has been caused is now the tenant won't be able to pay the zamindar revenue. And the zamindar has agreed to pay a fixed amount of revenue to the company and, eventually to the crown. And that is the right which is being, infringed upon, or the harm. So the reason I keep going back to this, because I'm trying to solve this in my own head. In 1950, would it have made sense to say, look, that was the right to collect taxes, and now there is a new stationary bandit in town called the Government of India. So, that's no longer a compensable harm. The only compensable harm is if we put in an additional land ceiling act and, redistribute land to, occupying tenants or, even the landless tenants. Do you think that logic holds together? That's not the way India went. But could this have been an option to sort of, avoid a lot of the zamindari land reform that India did in 1950?
I'll take a stab at that. I mean, I was with you, Shruti, till sort of the very last question that you posed. I mean, I think the zamindari land reform was really sort of a political necessity, right? I mean, it wasn't so much about laws, about politics. I think we've discussed this earlier, in private conversations. I mean, if you had the Raja of Darbhanga have more than 1 million acres of land, in some sense that was politically untenable and that had to be changed. So,
oh, I agree with you. My question is the other way. We could have avoided the problem by not having to compensate him. Because the Maharaja of Darbhanga is, his rights have been taken away as tax collector. His actual land holding itself is not that big, right? Whereas we virtually rewrote Indian constitutional law just to ensure that we can take away Raja of Darbhanga's, 2,400 square miles.
I don't know, Shruti. I mean, I think, it's simpler in that case, but at least the ethics of it are simpler in that case. But there were zamindars and there were zamindars, right? And so you could think of expropriating the Raja of Darbhanga without compensation. But someone you would call a zamindar might have 10 acres of land, right? I also, beat my head against this wall quite a bit about, is this a tax or is it ownership? I think for de facto purposes, actually, it was ownership. Sure, it was constrained by tenancy law and so on. if you have a piece of property and you have use rights over it, you have eviction rights over it, you can borrow against it. Like Tirthankar said, ownership is a bundle of rights. You're getting pretty close to having a large part of that bundle. So I guess I do view it as ownership, and which is why there was this, you had to. And then you had to compensate, of course, as you know, because you've written the right to property in the Constitution.
A couple of things in response to your question. First, the eminent domain problem in India. I mean, if you are tracking the history of it, probably the first large-scale use of something like it would be the railway land acquisition. But my impression, I'm no expert on that particular history, but my impression is that there was no central federal policy about this when the first railways came up. And the other thing to remember is that in 1860s and 70s, you still had a lot of surplus land, huge quantity of it. And the people who controlled it, whether they're princely states or zamindars or the local collector, they were parts in some way. They were allies of the colonial state. So there was no prospect of a significant backlash or protest about land acquisition. But there was still a legal angle to it. I think that needs more research. Maybe somebody is researching it now. But what happened after 1947? I mean, there were, of course, urban construction, bridge building, as you said, and quite a few other type of land acquisition. But what happened after 1947 was completely different in scale. And the fact that there were 2,000 river valley projects that came up, some of them in terrain which many people were already settled or land was very scarce, very valuable. And that was a completely different kind of problem, different kind of political problem. And we all know what happened. I mean, there were, of course, legal ways of doing this, but they also created such massive displacement and political issues that practically the entire movement became kind of politically infeasible. There are very few dams that has been constructed since Narmada, probably none. The eminent domain issue quite changed in scale between colonial and the post-colonial times.
And I think one thing, as someone who lives in the US and then thinks about eminent domain, I'm sure you've noticed, Shruti, which is that, I was looking back in our book, we make a reference to this 2005, Kilo decision in the US.
Yeah.
And so I went back and looked at that judgment. And one of the things that jumped out at me was, can the land be seized for a public use or for a public purpose? And so the US law says use, which is much narrower. There's debates about, is this sort of going into public purpose? But the 1894 law pretty explicitly says purpose. So the state has actually given itself enormous power right off the bat. And then that just persists past independence until you get this big pushback, after, as Tirtho mentioned.
Yeah, and on that, I think two additional points, which is, you're absolutely right. I mean, this public use, public purpose, they even debated in the Constituent Assembly, right, what the wording should be. And then at some point, the framers of the Constitution explicitly said, whatever way we phrase it, land reform is included, because we got to do that. If I wear my economist hat, right, what do I think of when I think of public use, right? It is something very, very close to public goods or quasi-public goods, right? It has to be non-excludable, non-rival. There has to be a collective action problem, right? Otherwise, the good is not going to be produced in the first place. And therefore, we must have eminent domain to avoid the holdout, right? So that's sort of the economic logic of it. Which means if you're just assembling pieces of land for, a hotel or a bakery, right, it's not going to qualify for public use or public purpose. Having said that, what is public use or not public use when you're in a socialist state? In my living memory, the government has owned Modern Bakery, right? In our living memory now, the government is trying to privatize the Ashoka Hotel. Right. So in a political economy where the government owns everything from, sick textile manufacturers to, bakeries to hotels to everything, now it's not clear to me anymore if this public use, public purpose distinction even matters in India. Right. And when they left it to the courts essentially used doctrine of legislative deference. Right. So they say whatever the government says, whatever the legislation says is public use or public purpose, or eventually became public interest, qualifies. The courts are never going to get into the point of, is this, good public use or doesn't quite match up to public use. So I think the American construct just simply doesn't compute. I mean, we use the same words, but they have just such an enormously different or, huge gap in meaning.
I guess the other thing that, I've been thinking about this, I expected actually to chat with you about this because I knew this was a shared interest. And, the sense I worry a little bit actually that the eminent domain law, especially when lawyers talk about it, you talk about it at a high level of abstraction. It really matters at what stage of economic development you are and sort of who are the winners and losers and so on, if you think of it as an economist. So, just going back to our discussion a little while ago of, sort of what is holding back sort of industrialization. At an abstract level, I'm a strong believer in the private property right and, maybe for a narrow description of public use and so on. But, if we talk about like politics and economics today, like the jobs problem in India is immense, right? And now if you think about, certainly acquisition of land seems to be playing a part in that. A big, there's what about $200 billion worth of held up projects. And so there's a lawyer's way of thinking about it, about the property right. And then there's me thinking that, if you could set up a factory that is going to create 5,000 jobs or 2,000 jobs, maybe the kind of property right we need here, or the kind of eminent domain law we need here, is different from what you might need, in the United States in 2020.
I think you also make this point very well in the book. In India, they're using eminent domain for a bunch of other very perverse reasons, right? We have bad land titles and you're worried about contestation at a later point. So the best way to get a clean title is have the government acquire land and then assemble it and, give a clean parcel of land to, whichever company wants to create the special economic zone, as the case may be. So bad land titling now has this unintended consequence of eminent domain. I was talking to some farmer groups in Gurgaon. This was a while ago, more than a decade ago. And I learned that farmers in India, in a lot of these urbanizing areas, Gurgaon is a particularly dire example because it's a very arid sort of area, right? It's not great for farming. So farmers are dying to sell their land, right? They really want to get out of it. Developers are dying to buy land. They really want to get into it. But they're not able to contract with each other. And as economists, to us, this is baffling, right? So we're like, there are people who really want to sell land and there are people who really want to buy land. So now where are the frictions, right? So we start looking at where are the frictions in the economy or transaction costs in the economy. The pain point, which is the change of land use certificate, right? This goes back to your previous discussion on, we are protecting farmers and workers to a point where they can't sell their land, they can't alienate. Right? And the few groups who can alienate, you can't change the kind of land use. You can't alienate to a non-farmer, right? Or you can't alienate to a non-Adivasi. If you do, the family which will buy your land has to have below X number of hectares of land. Otherwise, they go over the limit. Now, basically, I figured what we've done in India is we've created a dual land market, right? One if you have all the relevant permits and one if you don't have all the relevant permits. And the price in these two different land markets is quite different. And that's probably where this 4x market rate and 40x of the profit sharing and all that is coming from, right? So when you have two different land markets and you have two different prices, of course people can't agree on buying and selling parcels of land and putting it together. But it doesn't seem to have occurred to them that we need to simplify that whole process. The result is, it's very difficult to assemble land in India, so we need eminent domain to have development for jobs and so on and so forth. Which I don't disagree with, but I still think that solving sort of putting a band-aid on the problem, right? It's not really solving the root of the problem, which is why can't people transact on land in India?
It goes back to what Anand was talking about before, the fear of the market. And the fear of the market is very palpable, very strong, very intense when there is a case of, assuming you are losing your last bit of asset, which is a little land holding that you had inherited from your grandparents. But as I said before, it's often a case of an imagined kind of situation. The imagined world is full of exploiters rather than free contracting people. And that's a kind of mental block. It's a mindset that has been with us for a long time. It partly comes down from fear of the colonial history or partly from fear of the state, partly from real life situation as well. You are absolutely right. I think the legal way of responding to this situation, this impasse, if you like, has not been completely satisfactory. And what you have in land market almost everywhere is that there'll be some kind of political agency that comes into play. So the problem that you mentioned in Gurgaon, I'm sure it is going to get solved. If both parties are willing, it will be solved. But it will be solved not by the courtroom, not by law. It will be solved by converting maybe land into, as happened quite often in Western India, converting agricultural land first into pasture and then into waste and then into urban land. We have ways of doing it, and there are many experts working on it. But it does get resolved. It's just that it involves massive transaction costs.
And it involves politics. They finally, I think, resolve these matters by bringing in local political sort of authority or politically powerful people to bring all the relevant groups and negotiate, right? And I think it's that negotiation, whether it happens in court, whether it happens in the market. In India, it's happening through politics.
In fairness, a lot of the emphasis I've said several times already in this conversation, about this being a mindset, the market skepticism being a mindset, but not to oversimplify. There's actually also a real problem there, which is that, so one distinction that I think is worth noting is that I remember reading a report that came out, I think was in 2014, which was actually advocating for liberalization of land markets, with one big exception, which is for Adivasis, for people classified. There's different parts of the Indian farming peasant community, if you like. And the vulnerability of Adivasis in particular is a theme that sort of lasts. So I think the concern that participation in land markets can be risky for them is not something that I'm willing to reject without, given how much I know. It's very deep. I think we shouldn't think of this as just a problem in the way we think. It may actually also be related to the fact that our legal system is so corruptible. Those fears have some foundation in the legal system as it currently stands.
Absolutely. And I think the biggest problem is the paperwork required, right? So we've kind of imported a very colonial legal system to negotiate matters which are not coming from a colonial mindset and not coming from colonial property relations, right? And most people don't have the relevant paperwork. This again goes back to state capacity, right? We know now in modern day, we know based on Alexander Lee's work, how the old zamindari versus rayotwari system and how many officers set up sort of, revenue collection units affects modern day state capacity in India, right? That's another way to think about the long shadow. And even today, we don't have good land records. During COVID, right, we're realizing we're not good at recording births. We're not good at recording deaths. All the things that we think that a country that has biometric identification and things like that, we just kind of take it for granted, but that simply doesn't work. And I think in the absence of good land titling and, very well vetted local ledgers, it's going to be very difficult. And Adivasi is a particularly, powerless group when it comes to negotiating the legal system. But depending on which state you're talking about, it could be a different group. I think the issue that you point out is very thoughtful, that I don't think we can just kind of move from this completely paternalistic world to a completely freedom of contract world without additional, changes which are brought to bear.
In the book, person whose work is really interesting in this regard is Vadva, who's made this big push for sort of torrents type titling. And I think that was really important work, and it's had a big impact. And in some sense, that is the direction in which we're going, and all this digitization and so on is helping. But the problem, of course, is that you can digitize, but the question is, what is it that you should digitize? And I think a problem that goes back a long way really is something we allude to in the book, which is that when you talk about taxation, so there's the question of who owes the tax on this piece of land, and the other is sort of who can you buy it and sell it. And the registry office, which records the sales, doesn't necessarily coordinate with the folks who are collecting the property tax. And this is true for property that people in my family own, but I know, that the owner who owes the property tax, that name is different from the owner as in the sale deed. That's a sort of a laborious process to get to the bottom of each of those and then document them carefully. And of course, in places like Delhi, in urban India, it's even worse than that. As you know, to avoid the stamp duties, you would sell power of attorney, right? Rather than the property right itself. And so, I remember one of my friends telling me years ago, about Delhi, ki puri Delhi power of attorney mein bik rahi hai. There is, all of Delhi is being sold on power of attorney. So you get really bizarre situations where someone owns a piece of property, but he has a sort of third power of attorney.
Yeah. And the other part is also, that's why they say 4x the market price, because the market price that they're relying on is what the registration office is giving them. And that's a depressed price because that's the amount that is given in white, as we call it in India, right? So you have a piece of property. If it costs 100 rupees, you say it only costs 40 rupees and you pay tax only on 40 rupees, and on the additional 60 rupees, you sort of, exchange it privately like a briefcase full of cash, right? Using this power of attorney and other means. So the whole thing is a little bit, messy. The circle rates or the market rates have no bearing on reality. A couple of zeros are missing in each of those cases. So I think you're right. Like, the more I read what you're saying, the more I have an appreciation for just the complexity of this. Like, not just each area of regulation, but each piece of regulation itself. It's so messy. Like, you talked about Kilo, right? Kilo is a 2005, 2006. I mean, this problem has been there in the US even before that. But this problem of taking land from Peter and giving to Paul. So it's sort of like a private takings where the government acts as a broker. This is an absolute no-no in United States jurisprudence. And Kilo was sort of like the point where it became so stark. But in India, we have clauses for the government taking land and giving it to a private company in 1894. Right? We have a situation where the government is a private company. So now this idea of taking from Peter and giving to Paul, and can it be applied directly to Kameshwar Singh and taking his land and giving it to all his, landless tenants? Or can it be applied now directly to cases like Shingur, where you're taking from the peasants and giving it to Tata? It's just becoming very confusing. There is no sensible Indian jurisprudence you can apply to the principle of, can you take land and give it to a private company?
Again, I'm being amateur lawyer here, but I think public use versus public purpose, right? Public use is very clear that Sita or Arvind or Anand should be able to walk on that property, drink on it, literally use the property. That's a clear criterion, however restrictive you may find it. Once you say public purpose, then really all bets are off, right? I give it to the land goes to a private employer whose factory is going to hire 5,000 people. Does it satisfy a public purpose? Yes.
Yeah.
This is something that Anand was talking about before. I mean, what we understand by public purpose is kind of colored by developmental ideas. Development is a public purpose. Then it depends on how you precisely define development, what its contents are. So if it is industrialization, well, acquiring land for a factory is very centrally fits that idea. We have been living with that kind of language, that sentiment that development is public purpose. And we have also lived with the idea that development is a state responsibility. State intervention is very accepted idea. Of course, it will never be accepted to the people whose land is taken away. But legally, juridically, it's an accepted idea, but it's not going to be politically acceptable.
In Kilo, Sandra Day O'Connor, who was one of the justices who dissented, at one point she says, but there's nothing to stop the government and the courts from taking a Motel 5 and making it a Ritz-Carlton, right? If the only way we think about public purpose is tax revenue and number of jobs and bottom line, right? So she points out the sort of moral conundrum, right? But as economists, I struggle with this all the time. How can we build a liberalized, globalized market economy that wants to attract foreign investment and all these wonderful things if our mindset is still that development is state-led and development is whoever employs more people or whoever brings in more revenue, right? Like, the global order is resources need to go to their highest valued use. And you can't be plugged into the global order at the same time and have like this local politics which says, oh, the highest valued use is what works for this kind of politics or this party's manifesto or, that kind of development goal. That, I think, is a tension that can't be easily resolved. I mean, this is a good question to ask you. Is it possible to have this kind of liberalized economy that one hopes India will get to? That seems to be the big dream, without serious curbs and restrictions on the government's power to take property or eminent domain.
I think part of the answer will be in making markets, especially asset markets, work more freely without government intervention, without the government doing things with it, joining it as a super powerful party. I completely agree. And, I don't want to predict a trajectory, but certainly some good things have happened. I mean, I'm a digitization optimist, although I see from personal experience like Anand's that some of the wrong data get transferred into the digitized records, and there is really no way of getting rid of that. But it's going to be a messy process, but it's certainly moving towards more transparent process in most states. But I think the bigger question about how do you create a more liberal market order is very political. It has more to do with shedding some of India's very deep-rooted xenophobic nationalism and the political body language that displays to the rest of the world what you stand for. That's involved here. Now, that is not a matter of legal reform.
But I guess the other thing, Shruti, is taking us away a little bit from what Tirthankar just said, which I think is a great point. The whole issue with the property right is that while you can define it in the abstract, when it comes to a specific case, you really consider about whose property right is being taken away. It's quite interesting that sort of the Indian left, and I think other people have made this point, and Namrata Bahi has made this point very nicely, that, during the land reform period, the left wants a weak property right. But now, because the property is being taken away from Zamindar and so more recently, actually, the left actually wants a strong property right. So even for the sort of global investor, a big multinational may actually prefer India having a weak property right and the Indian government being very strong, because it's not that they fear they will be expropriated, but it can facilitate them getting the land that they need or something like that, right? So I guess what I'm saying is that secure property rights are not always good for capital.
I think in this, things change too quickly. We're not that far off. We just had crazy, retroactive taxation, right? We've had firms be expropriated during Indira Gandhi's regime, both domestic and foreign firms. We've had overnight bank nationalization, right? So, you're absolutely right that it depends on whose property, but I think it's very difficult to build that kind of global market order if property can be expropriated at any time. I agree with you that it's less likely to be expropriated from a modern day Kameshwar Singh than a modern day, not so powerful farmer. But I do think once you weaken property rights, you weaken them, for everyone. I remember when Shingur happened, I had written that this is reverse Robin Hood land reform. Because that's exactly what they were doing, right? They were taking from the farmer and they were giving it to Tatas. And they also did that in the late 19th century, early 20th century, right? Tisco was built on taking land from peasants and Adivasis and clearing it for the iron and steel mill. So this has happened before. It's just really hard for me to imagine a world where the nationalization hammer is not going to be arbitrary.
It's a tricky question. My sense actually is that, again, even with property rights, we're talking about sort of property rights in what? And it seems to me like property rights and land is sort of a special category of messy issues.
It is a special category.
Right? So I think I agree with you that foreign capital is not going to come in if you think that your shares or your profits or whatever are going to be retroactively taxed. On the other hand, I think, like I said, a weak eminent domain law that allows the government of India to run roughshod over someone as property right, get them land to build something, is not going to discourage foreign capital.
It probably isn't. In fact, in the very short run, it might even encourage it, right? So that's the trade-off people are trying to make with these new special economic zones and places like that in the short run, we should be able to attract the capital and hopefully that'll give us gains in the longer run. I know you have to teach soon, so I want to ask you one last, sort of big question. I know we spent a lot of time on land, and that's, many chapters in the book, but there's also discussion on, corporate law. There's also discussion on insolvency. There's discussion on environment. But one of the big questions I left with is law itself the binding constraint? You raise this, at the beginning of the book. At some points, it seems like law is the binding constraint. And at other points, it seems like that's not the relevant, constraint that's holding a particular sector or a group or the market back. Again, what is a good way to think about identifying this?
To rephrase the question, if it is a binding constraint on private investment, my instinct is that it is not. If there are other conditions that make investment possible and profitable, parties will usually find a way to bypass legal obstacles. They're not that great in India, despite all the bad scores on ease of doing business. It's not one of the really difficult business environments. However, I think the ways of doing it will need some engagement with kind of politics that especially a small or medium scale investor may find quite daunting. That's where the problem comes in. As we are discussing, if you have a really big firm doing kind of bilateral negotiation with the state government, there is no problem. But anything below that scale could be quite problematical.
In the period when the Indian economy was growing slowly, I think the messiness of especially land law and so on didn't matter that much. It could be that actually, you've plucked with liberalization, you got the low-hanging fruit and you grow really fast. And now this thing may be beginning to bite. So Tirthankar and I were talking the other day about, we were really talking about the corporate chapters and so look, if things are so messy, how come we're getting so much foreign investment? So one way to think about it is, it's really not much of a constraint, but the counterfactual is not clear, right? I was talking to someone else who was suggesting that, look, and I think Tirthankar made this point in our recent conversation as well, that foreign investment is coming into 200 companies or something, right? And in a different environment, you could have 10 times that much, and it wouldn't come into 200, it would come into 2,000.
I think that point is really well taken. As economic historians, I have a broader question just about, the way you research both the books and also a lot of your past work. This is going back to the head of the conversation. We were talking about, in India, the colonial state was an extractive state as opposed to a settler state, right? A lot of modern day economic history, like if you look at the Acemoglu, Johnson, Robinson kind of paper, if you're extractive or you're a settler economy, and then accordingly you will be coded. The same thing with, Laporta, Schleifer, that kind of civil law, common law binary, right? Now, you, on the other hand, do very thick sort of, qualitative economic history, right? I find it very difficult to identify if India was the victim of an extractive state or a settler state. How do you think about this problem, and how do you think about the way modern economic historians categorize India one way or another when you're doing this kind of thick economic history?
The works that you mentioned are of a very different kind. I mean, they're not really about colonialism at all. They're about comparative economic growth, using a model which figures colonialism. I mean, they're a test of a causal model. There is a great advantage in doing that kind of work. I mean, you identify a singular mechanism which is creating inequality, and that makes it easier to compare countries, whether that mechanism exists or not, or how powerful it is. But it's not really history of colonialism. So you have another bunch of people who would build this story based on what data they find, the historical processes, study. Our books are more of that kind. But of course, we are driven to this by that other literature. I mean, we would probably not write these books without that comparative history literature. When I teach this subject in the classroom, I have to tell the students that, look, there are different types of uses of these histories, and you have to keep in mind that they're doing quite different things. I mean, they're not doing the same thing. And if you, then going back to your question, if you apply this extractive state idea, take it too literally, then you will be a rather poor historian and understand the states in a very oversimplified way.
Just to reinforce what Tirthankar said, like the famous Acemoglu Johnson Robinson paper, though it has colonialism in the title, it's not a paper about colonialism. It's a paper about the role of institutions. Colonialism just gives them their instrument for their two-stage least squares method.
Yes.
But I think more generally, I think this work is really useful, Acemoglu and Johnson Robinson and Laporta, because they set agendas and they opened up the debate. So we were at a conference, Tirthankar and I were maybe 15 years ago, but these papers were really like hot off the press and everybody was talking about them. And so each person would be asked, so what do you think of the AJR paper, the paper by Acemoglu Johnson Robinson? And almost everybody said this really great work, but it doesn't apply very well to my country.
I can actually imagine that for each and every country that they have looked at, right? It's an excellent simplification. The other question on economic history, first of all, there is not that much economic history done on India relative to many of the other countries. And I think this might just be a more general problem of India being understudied, maybe even in macro or labor or other areas. But I can quite clearly see it in economic history. But the other part of it is a lot of the economic history for especially Europe is deeply interlinked with the religious history and the religious institutions. And that doesn't seem to be the case for India. Now, is it just that this is such a nascent field and that hasn't cracked open yet, and we don't have, more division in labor and specialization, for instance, like Shriya Iyer, and, is it that we don't have good records or we don't know the language of that time to disentangle this stuff? What's the problem in this kind of work coming more to India?
You were right. I think much of Indian economic history in the 1970s, 80s, when I was a student, was being done by historians rather than economists, as the case is now. The historians did economic history, but then left this field to do more cultural studies. And that created a very sharp division between the kind of things you talk about in religion and economic history, interface or intersection between the two. That doesn't mean that the intersection doesn't exist. Just like church organizations have been a very important part of organizing social life or economic life in Western Europe, you have temples and mosques are also very prominent. It's just that we haven't thought of studying the intersection, and the kind of mixed expertise that you need to study that sort of thing hasn't really developed. But as you say, there's a lot of such open areas which are waiting to be explored.
This little anecdote of visiting family back in Bangalore, saw this little room on the side, but there's a photocopier. And I said, what are you doing? These were temple records from 600, 700, 800 years ago, from the mathas of the tradition that my family is born in, is part of. And this is parchment. And they're in like a residential home being scanned. They're being done professionally, it's being made publicly available. But I think there's just a whole lot of that kind of stuff available. It's a matter of throwing the resources and the time and energy into exploring them and using them.
What sort of advice would you give Indian students who are listening in on, what are the big economic history questions in India up for grabs, or what kind of skills they should develop? Economic history requires very different set of skills than the rest of economics, right? It would be great if they are, bilingual or trilingual. It would be great if they know how to read ancient script. It would be great if they know how to do thick archival work. It's quite different than, learning R and Python, which is the current modern day prescription of getting into a PhD program.
I think actually the advice is difficult to give because there's some structural things that need to be in place. So for instance, I think there's a real bifurcation now between economic history of the type that's being done in economics departments in the United States, which really is statistical and is actually quite almost indistinguishable from what we would have called development economics.
Yeah, cliometrics.
Yeah. So that's quite interesting. And then there's a different kind of, the social historians, the traditional social historians work. I'm not sure what I would tell a student. I think you do have to be prudent about choices you make. In India also, you have to even stop thinking about India. You want to start thinking about top quality research institutions in Andhra and Telangana and so on. Absolutely. That are investing. You need a world which will actually reward you for spending time learning a language that is now no longer used, and so on. So, I certainly have intellectual fascination for this. But would I tell a student today, spend 5 or 10 years of your life doing this? I think it's really important, but there has to be sort of the institutional and structural kind of backing for it.
I have a very positive message in response to that question. Two-part to my response. First, it's extremely easy to enter this field because a lot of the documents are available in English. And for good reason or bad, the British colonial state loved paperwork. They produced loads of it, and it's all extremely well preserved, very easily accessible in some of the world's best archives. So the entry costs are very little. You can just jump in and start reading sources. The second thing I want to say is that we make the common error of first reading, say, Journal of Economic History article and then seeing whether we can write a similar paper for India. That's probably not the right way to go. It sometimes works, it sometimes doesn't. Or to think about history as a kind of everything around the colonial state or the developmental state. A very statist way, because a lot of these archives are actually state papers. If you get rid of these two biases, the core of economic history is in the Western world and we are just testing hypotheses using Indian data. If you shed that bias and shed the statist bias, you will find lots of questions. So the way to go would be to start, log into the British parliamentary papers, maybe fish out an obscure document, start reading it. Even if you do not end up with a research question, it will be an entertaining afternoon.
It is, yeah. Anytime spent in archives is an enormously fun day or a fun afternoon. Anand, you're smiling.
That's exactly right. I think we talked about how it's a privilege to be paid to be doing this.
Absolutely. Yeah, it's such a joy. And I think there's a smell that archives have. I always say that, the way you wake up when you smell coffee, it's like, some part of your brain wakes up when you go and smell really dusty parchment, in the deep recesses of an archive. How did you both write this book? What's the writing process?
It was pretty simple. We talked about the big picture, and then the actual writing, we pretty much wrote separate chapters. And originally the worry was that our writing styles might be so different that the books may come out a little jagged. But I think one reviewer explicitly said that he couldn't tell where one person's writing ended and the other one started. So there are a few chapters, and of course we've read each other's work and edited it and so on. And there are a couple of chapters I think that we worked on both. But I think allowing each other to write one chapter each sort of just allowed sort of coherence, and then each of us was the other person's referee, so it made things simpler.
I think the teamwork element worked extremely well, but that's the key to all collaborations. But besides that, I think we shared an interest in telling a story, and we were not burdened with what story we are going to tell. So there was a spirit of discovery that I think we both shared. It's quite interesting.
Again, the two things that run through both our books are, first of all, where did this law come from? And why is it so cumbersome in India when so many other things are? Those were the questions, but then the answers we had to just learn. We didn't know them going in. And the answer turned out to be complicated, vary across time, vary across land, corporate, etc., etc. So it was a process of discovery, I think.
What's your individual writing process like? Do you write every day? Do you sit in the same spot? Do you listen to music? How do you write?
I do my best work in a coffee shop.
So this, I assume, is in London somewhere, near where you live, and you just go every day to a coffee shop?
Yeah, well, the pandemic made it difficult, but I find a public place with some bustle going on around me and good coffee accessible very helpful.
That's wonderful.
Yeah, no, for me, actually, this has been a transition. My first half of my career, at least, I've done a fair bit of microeconometric work and a little bit of game theoretic modeling and so on. So this book writing business is only something I started after I turned 50. So I feel like a novice. I'm still learning how to do it. It's been fun, and I actually enjoyed the freedom that it gives you. I mean, the fun of the econometrics was that it forces you to think clearly in certain ways. It was always frustrating that you had to leave out big parts of what was fun and interesting. And I've enjoyed the flexibility of a book, which, you don't have to be straight and narrow. You can actually mention something that you find interesting. That's not exactly on point. But how I do it, I don't know. I'm still figuring it out.
And now the most important question during the pandemic, what have you been binge watching?
Well, my wife and I are addicted to Netflix, and
I'm so happy to hear that.
So many. I mean, we like not slightly, but quite a lot, thrilling, violent content. But we have watched so many that we mix them up. One episode gets added to another serial, and we are now completely confused, but we're still doing it.
What was the last thing you really enjoyed watching? Do you remember?
Yeah, The Tourist.
Oh, The Tourist.
It's set in Australia. Yeah.
I've also watched a lot of stuff over the pandemic. Hooked actually on something that's quite kind of low-key. It's called Ozark.
Oh, yeah. It's amazing. It's like it gets crazy. Just watch out.
Yeah, it's been really interesting. It's sort of quite more nuanced than many of the other things that get on Netflix.
Thank you so much for doing this. This was such a pleasure, and it was really such a joy to read the book, and it gave me an opportunity to go back and read the first volume. This is a very important input to my own work.
Thank you for inviting us, Shruti. It's a great pleasure. I should also say that, I know some of your work, and it's really interesting, including your work on property rights in particular, which I've read. And I think this is a great series that you're putting together. So learning a lot from all the guests. And so thank you for calling us.
Thank you.
Thanks for listening to Ideas of India. If you enjoy this podcast, please help us grow by sharing with like-minded friends. You can connect with me on Twitter at @SRajagopalan. In the next episode of Ideas of India, I speak with journalist Barkha Dutt about her new book, To Hell and Back, Humans of COVID. Also check out our new initiative commemorating 30 years of India's market reforms at the 1991project.com.